Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the McDermott, Will & Emery law firm in Boston. The IEEE is presenting this podcast in conjunction with my column that appears each month in Computer Magazine, the flagship publication of the IEEE's Computer Society. That column discusses legal issues relevant to people in the computer hardware, software, networking, and service businesses. In the last podcast, I discussed big data and privacy issues related to big data. This podcast will discuss some recent legal decisions affecting intellectual property, or IP, which is the topic of my July 2014 column in Computer Magazine. Over the past several months, there have been several court decisions that relate to IP and that will have significant impact on how disputes over IP are resolved. Most recently, on June 25, 2014, the U.S. Supreme Court decided the case involving streamed retransmission of television broadcasts. That's the Aereo case. As background, Aereo provides a retransmission and DVR service to its subscribers, enabling them to watch and record broadcast television on an Internet-enabled device. Broadcasters claim that Aereo's service amounted to public performance of the broadcaster's copyrighted works and allege that Aereo was liable for copyright infringement. The Supreme Court agreed. In a decision that will likely be scrutinized in the forthcoming days, the court said that Aereo's service was like the service that cable television systems provide. Because the copyright laws were changed in 1976 to apply to such cable television services, the court reasoned that those laws should apply to Aereo's services as well. The court voted 6-3 in favor of the broadcasters and against Aereo. This means that the case will be returned to a lower court where a preliminary injunction against Aereo was at issue. This decision strips Aereo of a defense to the copyright infringement claims against it. The court's opinion is interesting, and I recommend downloading it from the court's website and reading it. The court's dissenting opinion is important to read as well, because it took issue with the majority's analogy between Aereo and cable television systems. Another important Supreme Court case is Alice Corp versus CLS Bank, where the court again tackled the question of whether software is patentable. Using a two-step test, the court first asked whether the claims in Alice Corp's patents covered subject matter that's eligible for a patent. Because the subject matter related to methods for financial trading, the court said no to step one. The court reasoned that the subject matter was an abstract idea, which is something that isn't patentable. In step two, the court looked at the claims in the patents to see if they added something significant that, in combination with the abstract idea, could make the subject matter eligible for a patent. The court said no here as well. Compared with patent claims that, for example, describe taking a well-known formula and using it to control machinery, implement feedback to adjust that control, and produce a product, the claims in Alice Corp's patent did nothing more than implement the steps of the abstract idea. The court said that's insufficient, that something more was needed. A reason why this case is interesting is that it requires rethinking on how to draft patent claims that cover software. It reinforces the fact that claims that simply recite the steps of the software without anything more might be found unpatentable. Even taking the steps and describing them in claims as being run through generic computer components, a microprocessor, a memory controller, etc., that isn't enough. Another case of interest is one that the Court of Appeals for the Federal Circuit decided earlier this year. That court is the court in the United States that is responsible for hearing all patent appeals in cases originally lodged in the district courts in the various jurisdictions, that is, the various states. The Court of Appeals for the Federal Circuit is one step below the Supreme Court in the judicial hierarchy of the United States. A party who is unhappy with a decision from the Court of Appeals can, in fact, appeal to the Supreme Court. In this particular case, the Court of Appeals for the Federal Circuit decided a question about claim construction. An important aspect in patent infringement lawsuits is the so-called Markman Ruling. It's named after an older case called Markman. In the Markman Ruling, is the point where the court decides what the claims in a patent mean. After the meaning is set, the claims are compared with the products accused of infringement and the so-called prior art to determine whether there is infringement or if the claims are in fact invalid. A party who's dissatisfied with a district court's Markman ruling can appeal it to the Federal Circuit. The Federal Circuit has reversed lower courts' Markman rulings about half of the time. Because a Markman ruling is one of the most significant aspects and has one of the most profound effects in a patent lawsuit, the Federal Circuit was asked in the case called Lighting Ballast Control versus Philips Electronics whether it should defer to lower courts' Markman rulings rather than evaluating them independently on appeal. This is a question of deference, whether the Federal Circuit should defer to the district court in evaluating Markman rulings rather than looking at those rulings so-called de novo, meaning afresh or without regard to what the district court said. The Federal Circuit said it would continue its long-standing process of independently evaluating Markman rulings. This decision means no change in the current procedures where a party dissatisfied with a district court's Markman ruling can go to the Federal Circuit and perhaps have a 50% chance of getting that ruling changed. And it will have very little effect on the current rate of appeals of claim construction rulings. An interesting aspect, though, not directly affecting this case, is that in March 2014, the Supreme Court agreed to hear another case involving a pharmaceutical company as to whether the Federal Circuit should in fact defer to lower courts when Markman rulings are being appealed. This is almost the same issue as what the Federal Circuit decided on its own. And as I said, that decision was to not change the status quo. This fall, the Supreme Court will hear oral arguments in this other case to look at that question and decide, possibly once and for all, whether the Federal Circuit should defer to lower courts in claim construction rulings or whether it should revisit them anew and come to its own conclusion without any deference. So this is a very significant question that will be answered sometime after the fall of 2014. The last several months have been very active ones with regard to decisions in patent and other IP-related lawsuits. As discussed in my July 2014 column, other cases addressed issues such as indirect infringement, the amount of ambiguity that the law allows to be included in claims, as well as issues involving product labeling and false advertising that come from the body of trademark law. While I won't repeat what was discussed in the column in this podcast with regard to those cases, suffice to say that there's been a lot of decisions in the recent few months, and they are going to have far-ranging impact. I hope that you found this podcast helpful. Stay tuned for next month's column in Computer Magazine. Until next time, this is Brian Gaff. Feel free to contact me via email at bgaff@mwe.com. Thank you.